Hello and welcome. I'm Ashwin Mohan and you're watching The Law Street, presented by Legal League Consulting in association with ET Now. In today's episode, we will dissect two key policy measures from the government that will change the rules of the game for India Inc. The Insolvency and Bankruptcy Code and the Real Estate Bill, which became an act earlier this year on May 1st. We will first address the Insolvency and Bankruptcy Code, and to throw more light on this landmark reform, we are joined by two leading voices from the world of corporate law, Krishnava Dutt, Managing Partner at Argus Partners, and Alok Dhir, founder of Dhir and Dhir Associates. Gentlemen, thank you so much for taking out time and joining me on the show. For starters, can you both give a quick overview of the code? How does the framework help towards repairing impaired loans in a speedier manner? Krishnava, if you could start with you.
If you just walk down the regulatory history and see what we had from a legislative perspective was, of course, after the SICA 1985 came DRT in 1993, which actually implemented only in 1999 by the time the DRT Acts came out, because the diagnosis was that the courts had an overburden of cases and that's why they needed a new tribunal for that. But by that time, they realized the diagnosis was wrong. It was the issue was more systemic and not just a court overburden with cases, but something larger. And the answer to that was a SARFAESI in 2002. The SARFAESI also was in three pillars, which is the securitization, the asset reconstruction, and the enforcement. But what happened over the years, the securitization happened as a part more than recovery, as a capital release process. But the enforcement really was in fact effective for some time, till such time it realized the enforcement was only with dead assets and dead real estate assets.
All right, now that we have introductory comments from Krishnava, Alok, if you would like to add to what he has said regarding how this bill in fact is a game-changing aspect as far as the bankruptcy regime in India is concerned.
The problem in India has been that over the years, as Krishnava has rightly pointed out, there have been various enactments and they have been addressing certain parts and parcels of what are the overall problem that the country is facing. We currently have some 9 trillion crores of stressed loans in India, and our recovery rates are very, very poor. We are recovering about 25% of the amount due to the banks and financial institutions, and time for recovering the money is about 15 years for the bank. Even the winding up takes about 4 years. So as Krishnava rightly pointed out, there is a broken system. The system's not been working. IBC is perhaps the first attempt at a most comprehensive approach to restructuring and leading to insolvency, if I may say so. And this is based on a certain completely new architecture for insolvency and bankruptcy in India, and complete structural changes have been put in place. Primarily, the three basic structural changes are that we have now moved on to a creditor in possession regime against a debtor in possession, which was the SICA. Secondly, rather than the legal and judicial wisdom, it is the commercial wisdom which will now implement the enactment, and the creditors will apply their minds to see whether the companies can be rehabilitated or must be taken into winding up. And to put this all in place, we have completely new infrastructure which is being put in place, which is resolution professionals, information utilities, and forums for adjudicating like NCLT, DRT, the board, the IBI, Insolvency and Bankruptcy Board of India, and the NCLAT. The whole purpose for doing this is that we've had too many laws. Incidentally, the IBC repeals 2 and amends 11 legislations. They want to put in a time-bound process. They want to maximize value to the creditors, bring predictability to the system, which will end up promoting entrepreneurship, availability of credit, and create a robust debt market.
You brought up the issue of infrastructure, and in fact the key to the success of this code, many believe, lies in proper implementation, and proper implementation is definitely not possible if it's not backed by proper infrastructure. And in this case, of course, one needs to have insolvency professionals, one needs to have information utilities, one needs to have tribunals. So therefore my question is, what's the time frame in which relevant professionals can be tapped for this code and such infrastructure be created? And isn't that time frame a little uncertain? Krishnava, if you would like to add to that.
The key would be the insolvency professional here. And there are also the other infrastructural issues like the DRT, like the NCLT, We're not sure because DRT anyway has been bogged down by an overburden of cases anyway.
And Krishnava, the other problem would be, is there a ready-made pool of such professionals who are adept and who are well accustomed to take over this role of being an insolvency professional in the first place?
So I was very curious. So I said that who would be the people? Would it be, I don't know whether they would be advisors, someone from the big fours carving out, or there would be the other restructuring companies of the world coming in, or whether the ARCs, the other is about ARC, people who promoted ARCs will suddenly, so it's a guessing game. It's a guessing game. We're not sure. I've had yes and no's from both sides. I've actually been curious enough to go and speak to quite a lot of them. In terms of pool of skill sets, I guess advisors, people who've been in restructuring, people who've been in insolvency, bankruptcy, special asset management, those would be fundamentally the people. Special situation fund managers, these are the guys who would be coming in.
Alok, would you like to add over there? Because it's clearly going to be an issue to tap relevant professionals. And because if the relevant professionals are not tapped, then these institutions are not going to be manned properly. So do you see that as an uphill task for the government going ahead, Alok?
Ashwin, I think it's a very uphill task. I would imagine that infrastructure building and capacity building should precede enactments of this nature, because the enactments can completely come a copper if the capacity building is not there. Now, insofar as resolution professionals are concerned, there are lots of initiatives which are being taken in the country today, and there is a lot of people are coming up with setting up insolvency agencies, or at least planning to set them up. I'm sure some of the big four will be doing it, and some advisories and consultancies who are operating in the special situation space will do it. But primarily the government seems to be thinking that the pool of talent which is available, in as much as chartered accountants, lawyers, company secretaries, ICWAs, and people from the management background who have been operating in special situations and distressed assets would come forward.
In fact, now I want to get into the all-important insolvency resolution period, which is 180 days or plus 90 days, which is amounts to about 270 days, but that's only in certain exceptional cases when an extension has been granted by the relevant authorities. Krishnava, is the time frame sufficient? And do you expect any sort of challenges when it comes to settling cases within this time period?
So in a simple way, no. I mean, we can't see in 180 days, but I'm not sure whether that's a hard stop 180 days. I mean, it is intended to be by the legislation. It says that 180 days. What if not? There would be extensions, and I think the critical point is the intent behind it. And 180 days is directional to set the tone of the resolution to be in a timely, time-bound manner. It should be respected. Of course, it's legislated as 180 days, but I do see a lot of problems coming over that, because that 180 days start, out of that 30 days is the interim insolvency professional, and then from that another period. So I really don't think within the rabbit comes out within 180 days, but surely, I mean, that, as I said, it just sets the tone, and probably people, if it evolves, it may be, as he said, that probably the most important is the integrity and the efficiency of I mean, that's the key to this whole legislation, that we must have the infrastructure in place before that.
Absolutely. So clearly a step in the right direction, but there could be certain practical challenges on the ground. Alok, now I want to look at this entire bill from an investor's perspective. Do you think it will provide distressed asset investors a much-needed platform to access distressed investment opportunities in a transparent, reliable and time-bound fashion? And also, how is it going to be beneficial as far as ARCs and the lenders community is concerned? Because the lenders community is now beaten down with poisoned balance sheets.
Everybody is looking at this enactment from the perspective of change which was required to be brought into the system. The investors, the creditors, the private equity, the ARC, all of them were in a position where they were not clear as to what is going to happen and how we are going to recover money, whether the resolution process will work through the BIFR or not. Now, what this act seeks to address is, it puts a timeline. It says 180 days. Try to set it right, try to do a restructuring, and if a restructuring doesn't happen in 180 days, we'll go down the liquidation path. So the idea was to give predictability and a timeline to the system, and not to extend the timeline from time to time.
Time now for closing comments, and I want to address two very crucial issues. One is definitely going to be, what are the lessons that India can learn from overseas jurisdictions, because the the bankruptcy code is not something unique to India. It's been tried out in overseas jurisdictions also. Every jurisdiction, of course, has its own peculiar ground circumstances. So therefore, Krishnava, I want to ask you, what are the lessons that the government can learn? And could you illustrate how the experience has been in some of the overseas countries?
Like India, the usual average recovery is 25 cents to a dollar, whereas in an OECD country or UK or Singapore is as high from 70 as an average or a mean to even 90 cents to a dollar. Time period taken in India, as Alok said, it takes probably much longer. Why India? Even Southeast Asia. And the third part, which is very interesting, which I said why SARFAESI didn't work probably or work well enough, is because everywhere where the numbers are low, where the insolvency law is not there, we see there is a binary that in terms of countries where there is no insolvency, the enforcement is through dead asset sale, where really half the value, 90% of the value of the assets are gone before you can enforce it. Whereas in jurisdictions which has a robust insolvency law, there really is mostly a going concern sale, where you're talking about the M&A aspect of it.
All right.
So that's where it is.
Alok, I'll leave the last word to you. What kind of an impact do you think the new code will have as far as deal activity is concerned?
I would think that there is a provision within the enactment of bringing in the resolution plan, and the resolution plan can actually be given by anybody. It could be the information memorandum is to be prepared by the insolvency professional, and on the basis of such information memorandum, any third party can come in for an acquisition, takeover, amalgamation and merger. So there would be a lot of information available in public domain with respect to the financials of the company and operational information, and that's where the hope rests, that we would have credible promoters and incoming funds and such other entities who would be interested in reviving companies coming forward for this purpose.
All right, on that optimistic note, we have come to the end of this segment as far as dissecting the new bankruptcy code is concerned. Krishnava Dutt of Argus Partners and Alok Dhir of Dhir and Dhir Associates, thank you so much for taking out time and joining me on the show. But don't go anywhere. Coming up on the other side of Law Street, we take a closer look at the new Real Estate Act. So stay tuned and keep watching ET Now. Welcome back to the Law Street. After several amendments, the real estate bill has been passed, and it's going to bring transparency and accountability in the real estate sector, increasing consumer confidence and also, in fact, benefiting the sector as a whole. To talk more on this interesting aspect, and of course, it's going to be a game-changing move as far as the entire real estate sector is concerned, because it puts a lot of onus on the developers. It also makes buyers a little less risk-wary when it comes to making that all-important purchase. I'm joined by two leading voices, Siddharth Hariani, partner from Phoenix Legal, and NK Dilip, partner of Tatva Legal. Gentlemen, thank you so much for taking out time and joining me on the show. Siddharth, if I could start off with you, could you outline what are some of the key features of the Real Estate Regulations Act, and why do you think this represents a paradigm shift as far as the policy regulating the real estate sector is concerned?
So the reason this act has come into being is it simply says to promote real estate development, sales with more efficiency and for the benefit of a buyer. So that's the genesis of this act. Now let's go back to what the concerns were and how the act addresses them. To start off with, if I want to purchase a house, I really don't know if the developer will be completing it on time. Is the title clear? By when will I get it? And if I don't, what happens then? Now this act tries to address a few of those concerns. It has put up a regulatory body, and let me equate it to something like a SEBI, where before I can go to the public and start collecting money, someone is putting checks and balances. Can I go out there and start collecting money? So they will first approve a project, look at the plans, make sure the commencement certificate is in place, and the developer's title to the land is there. Once that is there, that is when the project can be offered to an end buyer or an investor to put money in. That's the first step. So therefore, as soon as there is something on the website of the regulatory body, you feel confident that let me actually book a flat in this project. Of course, that is backed by the track record of a developer and what the project is all about. Secondly, once I put the money in, is the developer utilizing it for my building or for my project?
Right.
The Act clearly says that 70% of the project cost has to be put in a separate account and has to be used only for the purpose of the project. Therefore, I get a little bit more confidence in that, well, my money is not going to be utilized for something else. Third, if there is to be change of plans, if there has to be a developer transferring his obligations to a third party, I turn into a stakeholder.
On that note, I want to quickly get in Dilip as well. Dilip, just to take the conversation forward, how do you think this bill or this act, in fact, represents the current situation and the current dynamic between the developer and the buyer? And why do you think today a buyer will feel fairly more confident before taking that plunge and buying the house? And also, if you could highlight what are some of the most stringent conditions that have been imposed on developers, at least they feel so.
One, I think, as Siddharth is saying, you need to know what you're buying. So till now, there was always this whole thing of what you sell at, super built up area, or what have you. So now they have really detailed out that you can sell only on carpet area, and the carpet area is defined, which is one of the key things that for an individual home buyer, he knows what he's getting. The second aspect is the utilization of money, which is kept as a ring fencing. So you have to have it certified by an engineer, an architect, who says that how much have you utilized, and only after you have spent the money can you draw the money. Now you have the timelines for delivery. The failure to adhere to the timelines can result in you being virtually thrown out of the project as a developer, freeze of bank accounts, replace you as a developer, and interestingly, they have given the first right of refusal to the Association of Allottees. In addition, they have also addressed the post-completion issues like warranty, which is for 5 years from date of possession, indefinite title guarantee. They have also brought in very stringent rules of failure to observe the act or the regulations made thereunder. Penalty which can go up to 10% for failing to register, penalty up to 5% for breach of the conditions of the act. So all these stringent conditions would ensure, hopefully, that the act is followed both in spirit and in form.
Point taken. I want to get in Siddharth's views as well. Dilip has articulated some of the stringent conditions, at least, that are part of the bill as far as developers are concerned. But Siddharth, what do you have to say about the liability of the promoters over here? There are some sections of the real estate industry that feel that some of these provisions are pretty draconian. Do you concur?
To a good extent, yes. Let's first understand how a real estate development takes place. Building a standalone building is not a developer's concern. He first proceeds with acquiring land. For most large cities, acquiring land within the city areas is a little tough, and therefore you start looking at semi-rural areas to acquire large tracts of land which are owned by farmers. The revenue records are not transparent, and therefore the title issue starts coming in. He's worried on the title issue first. He borrows monies at large cost to acquire land. Then comes the approval stage. The project needs to be built based on a particular set of plans and approval. And currently that can take long timelines, which is not completely in control of a developer. Also, once the project is launched and the first set of a commencement certificate is received, there are additional approvals to be put in place. Now, having said all that, the Act only says you start, you use the money, and you complete on time. It fails to address that there are various other aspects that the developer has to face. The intent is quite good, but this will lead to additional cost. the developer, if he fails to meet a certain timelines for either a title issue, which despite having tried to do his best to investigate, was there concerns which he could not have recognized initially, or approvals coming in late, could lead to heavy penalties, asked to vacate a project, or finally even there is imprisonment. So therefore, of course, the developers...
It can be as extreme as that.
Yes, and in a current environment when the real estate industry is facing a little bit of heat, they are finding it extremely draconian.
Siddharth, if you could list out the most important top 3 crucial areas that need to be addressed on an urgent basis by the government when it comes to this new act, both from a developer's point of view and also from a home buyer's point of view.
The 3 important points are, one is the approval timelines. I think that is extremely critical, not just for the developer, but for a buyer, because at the end of the day, he wants a house which has an occupancy certificate to live there happily without any issues. Second is for the utilization of the 70% funds. I have more questions than answers in this act of how does a 70% get utilized, what is the cost of the land, what is the cost of the project. If the developer himself says what the cost of the project is, you can inflate it and still take 100% of the cost of the project out. And the last bit I would simply say is, I think that if you do not complete a project, the answer does not lie that the person who is desirous of purchasing completes the project.
Dilip, your top 3 list?
I think the Act, if you looked at it, it's split up into 3 sections broadly: during development, failure to develop, and post-development. I think for the aspects during development, they've put out a detailed framework, and they seem to be having that a lot of doubt on all developers. This can lead to a stifling of the market, reduction in the supply, which all again increases the price to the home growers. The next could be how do you enforce these elements? The enforcement portion, just because there's a whole issue of imprisonment, will these fines and stipulations get enforced? What's the mechanism for this whole industry to enforce? So we hope that the regulator enforce this in a calibrated manner, so that people get predictability that if you do a small violation, you may get hit on the knuckles. If you do a serious one, there would be something that goes wrong drastically. So we hope that if that calibrated enforcement comes in, this act should be a benefit to the home buyers, and it also should address the industry's concern of professionalization and transparency.
All right, so net, an act in the right direction. Baby steps still being taken, but clearly, as our panelists pointing out, there are certain hurdles on both sides that need to be sorted out, and we can only hope that the message from our panelists reaches the government's ears. On that note, I'll have to thank both Siddharth as well as Dilip for taking out time and helping us understand the new Real Estate Regulations Act. That's all on this episode of The Law Street. Goodbye and thanks for watching.